Mr. Rosenberg, I don't think most lawyers and doctors understand how working with a legal firm closely can increase their profits, their business profits. Could you briefly explain how that may be?
Well, in the greater Kansas City area, given that we've been in business for a lot of years and we've handled at this point thousands and thousands of injury cases, motor vehicle, especially soft tissue injury cases, we have developed through our contacts through the years a list of chiropractors and medical doctors who, in response to our requests, will work together as a team in developing both the medical and the financial aspects of an injured person's claim to the benefit of both the injured person and the medical providers who are taking care of them. So one thing we see when we encounter chiropractors who are essentially working on their own without the benefit of working together with an experienced legal team, they tend to treat too long, too many visits over too long a period of time without considering issues such as how long ago was the accident, how much damage was there to the vehicle, and what's their authority, what's their medical authority in order to enhance their chiropractic authority. What's their medical authority? What doctor, which doctor is approving of a long course of treatment like that? When we're in a position to advise the chiropractor that after a certain amount of time and after a certain number of visits, especially if the patient has plateaued and doesn't seem to be improving as rapidly as they were in the past, we can put them together with a medical doctor who's not interested in stealing their patient, but will give a valuable second opinion based upon an examination of their chiropractic records and an examination of the patient as to whether or not the course of treatment is appropriate. And if it is, that medical doctor is going to make that opinion, give it in writing, and return the patient to the chiropractor for additional, if at times somewhat altered, chiropractic treatment. That's going to mean in the long run that case has more value. It has more settlement value to an insurance company because the chiropractic work has been confirmed by a medical doctor who, after all, let's face it, in the real world has a higher reputational standard than chiropractors do, and especially together both practitioners have a higher reputation than a chiropractor acting independently. So it's going to result in a greater case value. It's going to be easier to satisfy the patient in terms of the amount of their settlement. More, if not all, of the chiropractor's bill is going to be paid, and less frequently are we going to have to ask the chiropractor to reduce their bill. So it becomes a win-win situation. We tend to stay out of court more often. We've got a doctor who's confirming the efficacy, the appropriateness of the treatment. More of the chiropractor's bill gets paid, and because a lawsuit and a trial aren't necessary, the chiropractor's bill is going to get paid sooner too. And I know that's important to a lot of chiropractors, just as it's important to us. So working together as a team, and it really is a four-person or four-entity team. We've got the patient, we've got the attorney, we've got the chiropractor, and when need be, we've got other medical care practitioners, not limited to just an MD alone, but specialists who can evaluate the chiropractic treatment, approve it, and if it's medically appropriate, and it usually is, send that patient right back to the chiropractor for more treatment. So that's my view of what we can do to enhance the business of the chiropractor, to ensure that they're going to get money, get it timely and in a decent amount, and then be able to move on to the next set of patients.